What's the Church of Scientology so afraid of?
This is SPTV.
Hello. Oh, look at me. I forgot to put up our little names again. I always do this these days, Zach.
That's your new shtick.
Hey, thanks for jumping on here with me on a moment's notice. I've got about 10 minutes or less to start and finish this video, which will probably work in our favor here. I have been informed by some of the finest minds in this sector of the Galactic Federation that a ruling that was issued on Monday in one of the trafficking lawsuits against David Miscavige does mean the court has considered David Miscavige served and a party to the lawsuit. I have the document here. I want to show you the, of course, I had to consult one of the other finest legal minds in this sector of TGAC. Okay, so check this out. Let me zoom in on this a little bit. Okay. So there was a hearing. There was a hearing on Monday. And let's see. Just wanted to show everyone a little bit of the proper paperwork here. And we're going to jump forward. So now look, this is Jane Doe versus, I finally said versus. I get so much crap in the comments for saying verse. Jane Doe versus Religious Technology Center, Church of Scientology International, David Miscavige, Gavin Potter, Bridge Publications. Okay. Now, guys, every defendant in this lawsuit has already been served officially other than David Miscavige. All right. So that's why the language in this ruling is noteworthy. So look at here. There were some things that were denied, and that's fine. All that was expected. Let's look at line 17. The court discharged the order to show cause regarding failure to file proof of service of summons and complaint because proofs of service have been filed on defendants or defendants have filed responses. Now, I asked some of the other finest legal minds, what does the last part of that sentence actually mean? If it says, or defendants have filed responses. I said, it still sounds like it's up in the air a little bit that, you know, maybe they filed responses that said we haven't been served and the court is still waiting to rule on it. And I was told, well, no, if you file a response to a lawsuit, you've been served.
Exactly.
And so I'm just going to pull up the language one more time. I'm sorry to be doing all the talking when you're the expert here, but okay. Right. The court discharged the order to show cause regarding failure to file proof of service of summons and complaint because proofs of service have been filed on defendants or defendants have filed responses. To you, does that language mean the judge said, we're putting this to rest? All defendants have been served.
That's certainly the way I'm leaning. I think it leads to one of two possibilities, but I lean in favor of this one. At any point, anybody could file a motion to say, oh, I haven't been served, but now the burden is on them to show they haven't. To this point, it's been on Jane Doe to show they have been served. The court has functionally deemed them served, and now it would be upon one of the defendants to say, no, I haven't, and here's how I can prove I haven't been served. And it raises the issue of how do you prove the absence of something? Because by virtue of filing the motion, you're acknowledging the existence of this lawsuit. And that's the second sentence you talked about. Mm-hmm. Or defendants have filed a response.
Okay, good. There's one thing I feel like I'm still not totally clear on. Well, I'm sure there's many more than one things. The order to show cause, regarding failure to file proof of service of summons and complaint. I'm not clear on who that order would have been directed to, the plaintiff's team or the defendant's team.
It would have been directed towards the plaintiff's team. As I understand it, in California, that's a standing automatic order that exists probably by court rule. In Oklahoma, we don't have a show cause order. If you don't have service on somebody within 6 months, the case is dismissed unless you go before the judge and ask for more time. So Oklahoma has a version of this. It's a administrative dismissal. You can refile it later, but if you haven't gotten service on somebody in 6 months, it either gets dismissed automatically or before 6 months runs, you have to go ask for more time. And this serves the same thing. Hey, we can't just let this lawsuit sit in limbo forever. Come tell me what you've done to try and get service and what your issues are, and we'll see if we can help solve those.
Okay. And, you know, I don't know much, Zach, because I grew up in a cult, but I'm struggling to just mentally break down this sentence structure of, I'm just going to bring it up again for the viewers. Order to show cause. regarding failure to file proof of service. Whose failure is being whose prior failure is either being accused or referred to here?
So
The plaintiff, obviously.
Yeah. So this is just fancy language that essentially says, plaintiff, you filed a lawsuit. You have an obligation to serve the defendants, all of them, individually and together. And whether you serve some of them or none of them, if somebody is not served, you have by this deadline to come back in front of the judge and say, Judge, here's everything we've done. And we actually saw that when it was another case, maybe one of the cases where they said, they went in front of the judge and said, Judge, here's everything we've done. We're getting locked out. Nobody's answering the door. We need more time. And the judge said, sure, no problem. That's super routine. It's really aggressive language for basically give me a status report on where we are.
Got it. Okay, so one last thing here. I'm sorry. I just have to.
That's okay.
Sure okay. So correct. Tell me if this sounds right. It is the defendants who would have at some point prior to, this filed something that said accusing the plaintiffs of failing to file proof of service, right?
No. So this is a standing order. When the lawsuit is filed, this is probably calendared automatically by the clerk's office, accordance with court rule, 6 months, 4 months, 120 days, whatever. It's automatically scheduled. If you don't have service before that date, you have to automatically, there's a hearing set. You go in front of the judge and give the judge a status report. In this case, because the proof of service was filed or the defense filed a response, which in this case, I believe it was the proof of services were filed for the substitute service. In that case, the judge will then strike that. Okay, there's been something filed since within this time frame. You don't need to come in front of me. Now the case will move along in the normal course of the litigation.
Very interesting. Some of the other finest minds in this sector of the galaxy have told me that because this lawsuit technically is on a bit of a stay, a bit of a hold until February, as far as discovery goes. We should not expect to see Miscavige personally file a response to this lawsuit at this point. Does that make sense in your opinion?
It could be either way. He's going to have a time frame. Sometimes it's like in state court in Oklahoma, it's 20 days. In federal court, it's 21 days. There'll be some time frame he has to file a response. But if the case is stayed, if he doesn't file a response, the judge is probably not going to get terribly bent out of shape. But arguably, if I'm the plaintiff, I'm going to argue you still have that 21-day window. Once you answer the complaint, then the case is stayed. We can't conduct discovery. There's nothing we can do. The case is stayed. But technically, in my opinion, that calendar is still running because that pleading is filed. There's just nothing to do after the response is filed.
Right. Okay, good. All right. Well, we knew from the beginning this was going to be a very short and sweet video. I just wanted to take the opportunity. I've had word of this for several days, and I was like, you know what? I gotta make sure I understand it, because it's one thing for someone to give me information. It's another thing for me to be able to come on and point to a document and point to the language and claim that it says what I'm, told this thing means. But I just wanted to get that out of the way.
Sure.
So. Thank you guys for joining us for this short and sweet little SPTV video this Saturday evening. If you're not yet subscribed to Zach Morgan's channel, you can find him on YouTube at Your Lawyer Friend Zach Morgan. Anything else you want to add?
No, happy Veterans Day to everybody. If you served or have family members who served, thank you very much.
Happy Veterans Day, everyone. Talk to you soon.
Okay, if you want to see my rock and roll songs, click right on this guitar. And if you want to see a different one of my videos, then you could click right inside here. If you have subscribed or not, subscribe